Hafa day, everyone, and thank you for joining me today. I wish this were a gathering for us to discuss where we could celebrate my birthday party tomorrow, but I think there are other more pressing circumstances that transpired this afternoon at the board meeting. I'd like to offer you some words at this time. I recognize that as the general manager, I am in an unclassified position. I serve at the pleasure of the board, and I acknowledge their decision to replace me. I am disappointed, however, that despite the positive and noteworthy accomplishments that I've made with the Port Strong team, the Port Users Group, and our local and federal partners over the past 10 months, the board chose to dismiss me from my duties based on a report prepared by legal counsel that is filled with inaccuracies, distortions, and poorly reasoned legal conclusions. But most of all, however, I'm appalled and saddened that 6 employees, most of them longtime members of the Port family, have lost their jobs as a result of a politically motivated investigation. My heart goes out to these employees and their families, and I can only imagine how devastated they must be. I've had the privilege of serving in top management positions with the government of Guam the past 8 years and have earned the reputation of being an excellent manager. I also hold the distinction of being the first female to lead both the airport and the seaport agencies, which I have tried to do with courage and determination. What emphatically drives me to succeed is the responsibility to my employees to do what is right. I am always a firm believer in an open and transparent government, free from political intimidation and retribution. I feel it's important for me to relay to you additional details which will hopefully shed some light on the events that have unfolded the past few weeks. On November the 29th, before 11 o'clock, I was told to report to Adelup to meet with the Governor's Chief of Staff, Frank Ariola. The Chief of Staff stated that there was a report prepared by the legal counsel for the Port concerning a claim for workman's compensation filed by a Port employee, which implicated me in misconduct and potential criminal activity. The accident involving the employee occurred months before I started working at the Port. To the best of my knowledge, the Port had not disputed the employee's rights to compensation within 14 days from the time it received notice of the injury in September 2011, 5 months before I was appointed to the Port. An inter-office memorandum prepared by the Port Safety Administrator, who was responsible for processing worker compensation claims, requested funding for off-island medical treatment for this Port employee, and a travel request and authorization, or TA, was included. The inter-office memorandum and TA were routed to and approved by the Deputy General Manager, the Corporate Services Manager, the Personnel Services Administrator, and the Comptroller, who certified the availability of funds. Relying on their prior approvals and after obtaining additional information from the Safety Administrator, I subsequently approved the TA. The TA was routed to Adelup as required by the Chief of Staff, was flagged, and the board chairman was then called upon to explain the circumstances surrounding the TA. I was stunned when the Chief of Staff mentioned that I was being accused of misconduct for my actions because I've always discharged my duties in an appropriate and prudent manner. Obviously, the press release issued by Adelup on December the 6th stating that I was not a party to the investigation was not true. They were privy to the report from legal counsel as early as November the 29th. The Chief of Staff then offered to have me transferred to become the General Manager of GVB. He told me in no uncertain terms that my options were to go to GVB, resign, or be fired by the board. I challenged his logic about having me move from one government agency to another if I was involved in any misconduct. Agreeing to transfer to GVB or resign from the Port would also suggest that I concurred with the report's findings, which I was not prepared to do. The Chief of Staff expressed that there was some concern about my willingness to take adverse action against targeted employees. I told him I was not willing to resign because I did nothing wrong, and I was prepared to stand on my principles. That same afternoon, I received an email from the Vice Chairman of the board, Mike Benito, referencing the fact that I had had an earlier conversation with the Chief of Staff regarding, in Benito's words, administrative issues, and that Benito, quote, wanted to work this out to ensure no more negative light is thrust upon the port, unquote. He asked me to meet in the morning to discuss how we could move forward in the best interests of the port and that Frank Ariola could be present as well. I met with Mike Benito and Frank Ariola at Adelup the following morning, November the 30th, and they reversed their position regarding my continued employment with the port. They told me that I could stay at the port, but that my continued employment was conditioned on me agreeing to take adverse action against the targeted employees. I assured them that if I had evidence that any adverse action was called for, I would not hesitate to carry out my duties, but that I would not rubber stamp any notices of proposed adverse actions. Instead, I insisted that they provide me a copy of the report by counsel, to which they continually referenced, so I could start my review. That Friday evening, I received via email a copy of counsel's final report without the exhibits referenced in the report. The report was obviously drafted with the intention of reaching the results that had been predetermined at a board meeting held at the legal counsel's office on October the 19th, a board meeting which the way was convened without notice to the public and was unrecorded, but attended by all members of the board. The exhibits to the report were subsequently emailed to me on Sunday evening. The following morning, December the 3rd, the board asked me to comment on the report. I declined to comment at that time because I had not had the opportunity to complete my review with all of the exhibits. I also stated that it was important to see the drafts of the notices of proposed adverse actions, which identified the employees, the acts they allegedly committed, and why their conduct and actions violated the personal rules and regulations of the port. Counsel was instructed to prepare the draft NPAAs for my review and consideration. Counsel insisted that it was important for him to prepare a summary, but that he would also prepare the NPAAs. On December the 4th at 5:42 p.m., I received legal counsel's supposed findings of fact and conclusions of law, which were filled with inaccuracies, distortions, and poorly reasoned legal conclusions. Legal counsel did not even bother to interview me or seek clarification on any matters. The findings of fact and conclusions of law were obviously drafted with the intention of reaching a predetermined result, which was not surprising because the employee who was seeking workers' compensation was perceived to be a political enemy of the governor, allegedly responsible for altering the Calvo Tenorio platform known as Blueprint 2020. In fact, the Chief of Staff directly told me that this entire exercise was all about getting this employee fired, and that I, in his words, was collateral damage. One example of how counsel bent or ignored the facts to reach the results he wanted is that counsel accused me of approving employees' leave since July of 2011, ignoring the fact that I did not start working for the port until February 2012. Many of the material events, including the accident which gave rise to the request for worker compensation, occurred in September 2011, 5 months before I joined the port. I did not have personal knowledge about the accident, since I was not at the port at the time. I also did not have personal knowledge as to how the port initially responded to the accident. As in many things which happen at the port, especially things which happened before my arrival, I have to rely on information provided to me by other managerial employees and subordinates, many of whom are longtime employees with invaluable historical knowledge. At the reconvened meeting on December the 5th, I informed the board that I was not prepared to issue the notices of proposed adverse actions against the employees for the following reasons. First, although I had not, and still have not, seen the NPAAs, I understood that the NPAAs were drafted by council and based solely on the report. I knew just from the allegations against me in the report that the report was deeply flawed and filled with factual inaccuracies and unsustainable conclusions. It would have been reckless and irresponsible for me to base any decision on what was contained in that report. Second, since council accused me of being an accomplice in the misconduct at the heart of the NPAAs, I was probably disqualified from taking action against the targeted employees.